Greetings, everyone. I, Khushbu Chawla, member of Team Legal Vidya, welcome you all to the second class of AIB 10 Days Crash Course. So, without any further delays, I would like to welcome the honorable speaker of this course, Advocate Nivedita Kondenya, to take the session forward. Over to you, ma'am.
Thank you, Khushbu. Good evening, all the participants. So, in today's session, we will be dealing with the three laws, basically six laws. We will be dealing with the CRPC, Indian Evidence Act, and IPC, and the new laws which have been introduced, BNS, BSA, and BNSS. So, Khushbu, please confirm if the materials have been shared to them or it will be sent after that.
Yes, ma'am, the material has already been shared.
Okay, okay, fine. So, since I have sent you all the materials, you can go through it when we will be discussing here. I will also get it opened here. I will share my screen also. Just wait a moment. So, in today's session, I will be telling you about what are the important topics from these three subjects and what you will be needing to study regarding the new criminal laws. And then I have sent you some sample questions also, but they are not wholesome. They are just for the sample purpose. And in this PDF, you will get all the topics. I have listed some important maxims also. I couldn't say that it is inclusive because there may be other maxims also, but I have listed some very important maxims is which is found repeatedly in the papers also, and it is very common in all the competitive exams. Then we have some important principles and some important points. So let's begin with IPC and BNS. So for IPC, some very important topics include number one are the general principle of the crimes and some important maxims. So while you will be in the examination hall, you will have the Bare Act, but you could not get to bring any book regarding any subject. Therefore, you have to memorize these principles. You have to memorize these maxims also. And regarding the principles of crime, I have basically these maxims cover the principles which are enshrined through all our acts, all our criminal enactments. Some of them are this actus non facet trium mense tria, which is the foremost important principle of the law of the crime, which says that to commit an offense, there has to be a guilty mind, and then it has to be accompanied with the actus reus, that is the guilty act. So, where if say suppose anyone is committing a particular act which is an offense, but he doesn't have the guilty mind, then there might be some different consequences. And if suppose someone is having a guilty mind, but he is trying to commit the that act to pursue that intention, but in between he's stopped and he could not commit that act, right? Or maybe he would be preparing for that particular act. So he, as per the law, he will not be committing any crime. However, there are exceptions, and there are some offenses also where even at the preparation stage you get punished for an act committed, right? So say for example dacoity, the if someone is found if a group of persons is found to be preparing for offense of dacoity, then they will be punished for at the preparation stage also. Otherwise, in the general principle of law, at the stage of preparation, till the time that act has not been attempted, you will not be punished for a particular offense, even though you are having a guilty mind. Okay, coming on to the next principle, it is crimen trabit personam. It means the crime carries the person. The meaning of this maxim is utilized in under section 2, where intra-territorial jurisdiction has been dealt with under IPC. Then we have this ignorantia facit excusat and ignorantia juris non accusat. That means ignorance of fact is excusable, but ignorance of law is not excusable. And we have it incorporated under the chapter of general exceptions under section 76 and 79, where it is said that if someone does an act or omits to do an act under the mistake of fact, then he could claim general defense, right? But if he claims ignorance of law, then there is no defense, because it is presumed in the general principle of law that uh, uh, every person knows the law, right? So ignorance of law is not an excuse. So in this way, there are several maxims here. uh, there is doli in capex, which is section 82 of IPC, where it is said that uh, the children below 7 years of age are not capable of understanding what is right and wrong. They are not capable of understanding the consequence of whatever the act they are going to commit, and therefore they are not held guilty of any offense under the act. But at the same time, in the further sections, section 83, if that particular child is above 7 years and below 12 years, then it will be considered by the court of law if he is able to understand the nature of the act he has committed, or if he has this particular knowledge that whatever he is going to commit is an offense, and it will be resulting in something very bad, right? So he will be after considering this the nature of the child, the knowledge of the child, and his age, then he or she will be punished. Then we have some on point number 30, voluntary non-fit injuria, which is also a maxim of law of tort, but here under say section 87 to 93, we have certain exceptions where it is said that whoever is consenting to suffer an injury, it means that the doer or the committer of the injury is not guilty then. Okay. mm, then we have okay, so you can go through it all the maxims. Coming on to the principles of criminal liability, it is one of very important topics in the law of crimes, and here we will be discussing some principles which lays down the foundation of the law of crimes, right? There are certain wrongs which are considered serious, and it has the gravity to affect the society at large. It has gravity to inflict some kind of negativity in the society, right? So these particular acts or these wrongs are serious and grave nature, and due to its nature, it attracts greater punishment, which under our criminal law we call them crime or offense, right? But there are certain wrongs which is only affecting a particular person, and that is called as civil wrongs. So the fundamental principle of criminal law is that to in order for an act to be a criminal act, it has to be done with mens rea. It has to be accompanied with the criminal intent, right? Without this intention, the criminal intention, no act would be called as a criminal act. Then that particular criminal intention have to be accompanied with the actus reus, the guilty act, and these two basic elements of crime form the two elements of crime, form the crime. moving further, there are four elements which go to constitute a crime as a whole. Number one, that they should be a human subject under legal obligation, right? You cannot prosecute a, say, suppose goat. You cannot prosecute a goat saying that it has trespassed in your property. You cannot prosecute a lion saying that he has killed certain person. So there has to be a human subject who is committing or omitting a certain act, right? And then only the element of crime would be, and then only the crime would be committed. So number one element is there should be a human subject who should be under legal obligation to act in a particular way, who should be under legal obligation to omit certain act. Okay, then there has to be the mens rea, there has to be the actus reus, which is to be committed by that human subject. And due to the result of that mens rea and the actus reus, there has to be an injury inflicted upon human being or to the society or to the property. Okay, and to make good the injury and to deter such kind of activities, the law of crimes is there, so that it can put on some sanctions, it can punish the people. So this is the principle and elements of the crime. Then we the other important topic in IPC is the offenses affecting human body. See, IPC has a large number of offenses. It has 511 sections, but you are not supposed to read all the sections. You are not supposed to go through all the topics in this because we are running short of the time. So you have to focus on these basic and important topics, which are always getting repeated in the examination. So the topic of offenses affecting human body is of very much importance. It has uh, uh, it contains a very serious acts against the human body. It contains murder. It contains culpable homicide, attempt to suicide, abetment to suicide, and all these offenses. So you have to be reading carefully the chapter 16 of IPC, which is from section 299 to 377. So go through all the sections once. You will have the bare act there, and you can, whenever any question appears from those sections, you can go at once and you can attempt the question. And in BNS, their provisions are almost the same, but there are certain differences regarding the seriousness of punishment, regarding the gravity of act, and some offenses have also been, since it has been decriminalized by the court, so it has been omitted. So you will find from section 100 to 146 in BNS the offenses affecting human body. So go through it once, the section. Also, on the conceptual side, remember the difference between the culpable homicide and murder, and be very clear about all the five exceptions which have been provided under section 300 to murder. So section 300 talks about the culpable homicide, which amounts to murder, and then it talks about culpable homicide, which does not amount to murder, and then we have these five exceptions. Can anyone list those five exceptions? Okay, fine. Uh, so the five exceptions under section 300 of IPC and section 101 of BNS. Number one is grave and sudden provocation, right? So you must be heard. There was this movie on this particular topic. It was a very famous case. Also, it was a movie based on the real incident of KM Nanamati. And there was this person KM Nanamati. He was working in the Navy. He was an officer, and he so as per the facts of the case, he saw his wife with his friend when he came back, and he was so provoked because he felt cheated. and he was so provoked that he went back to his home. He brought his gun, and then he killed the other man. Now, when the case was there in the court, he raised this exception. He raised this defense that he has not committed murder because it falls under exception 1 of section 300. But then the court reasoned that there was this period of which we the court called the cooling down period. So grave and sudden provocation has to be very sudden. Provocation so grave that you could not think of anything. You have no time to think rationally. You cannot assess the gravity of the act which you are going to commit, and you do commit that act, right? So that is grave and sudden provocation. But in this case, the court found that the person, he saw something, he was provoked, but then it was not sudden because he went back to his home, he fetched his gun, and then he killed. So there was certain cooling down period which was sufficient to cool down a person's provocation so that he could think rationally. And therefore, this exception was rejected by the court, right? This defense was rejected by the court. So similarly, we have certain exceptions relating to consent. If someone has consented, then consented to suffer some injury, uh, and then he dies. So it's not committed. It's not a murder committed by the other person, but it's a culpable homicide. And similarly, the other exceptions, right? Coming on to the next topic, which is criminal act by the group or groups of the persons. So under IPC section 34 to 38, you will find the principle of joint liability, vicarious liability, and common intention. So you have to remember the difference between joint liability and common intention. You have to you have to remember these principles, and then you have to go through these sections. Just read the lines of the section and be thorough about it, so that while in examination you could access at once. Then the topics like criminal trespass and defamation is also there, so you can just go through the sections, and it's sufficient in for that. Now, with this, we are done with the topics, important topics under IPC, which you have to focus upon. I will send you a PDF of important case laws also. And let's move forward to CRPC. So under CRPC, you have to be well versed with the definitions, right? So I have also listed some important definitions here. See, for example, charge, complaint, High Court, India, investigation, etc., etc. So be well versed with these definitions. Just go through it once. And okay, so in respect of BNSS, the definition of bail is provided in BNSS, which is not there in CRPC, and similarly there are certain other definitions also which has been added upon, but bail is very important. So just read it once, be very clear about it, and I would suggest you to read the primer of the new criminal laws which I have shared with you, right? It is very wholesome. It has this comp let me open it for you, just a second. Okay, so I have shared this primer on new criminal laws. It is prepared by West Bengal Judicial Academy, and it is very wholesome document through which you can go through, and it will clear all your doubts. You will not be needing any other document, any other book on the new criminal laws for this examination purpose, right? So okay. So here you will find some highlights of the objects and reasons of this particular in the new acts, and then you will find some important changes in the Bharatiya Nyaya Sanhita and sorry in Indian Penal Code by broughting up the Bharatiya Nyaya Sanhita. So you will see here scheme has been laid down, the chapters, the sections, the content of the chapter. It is all at one place. Then they have in this document they have also provided some important definitions which have been inserted under the new act, which was not there in the previous act. For example, this definition of gender, it now also include transgender. So all the advances which we have achieved through the court's judgments and other commission reports, it all has been incorporated in the new acts. So it is a very important piece of document. Just go through it once. All the salient features, you have to go through all the salient features, and then go through with these major changes. So it is in tabular form, and it will not require much time from you, and you can just go through it. So you will get this very uh, uh, important insight about both the acts, and it will be very quick. Now also they have provided this scheme. So if something has added new to the new act, then they have provided it in the green form. If something has been deleted, it is in red form. If there is no change, then there is no change. And if there is certain clause which has been altered, it was there, it has been retained, but there it has been altered, then it is in blue column. So it is very easy to navigate and understand, right? Now let's be back to CRPC. So under CRPC, apart next to the topic of definition, you have to be well versed with the topic of criminal courts and offices. So you will find under Chapter 2, Section 6 to Section 25A, all the important courts which will be constituted under the CRPC, and all the important offices which is being constituted for the proper administration of criminal justice. You will find the similar in BNSS also. So yeah, just go through it once. Go through the content table of your Bear Act, and be well aware what comes where. Right. Coming on to the next topic is of arrest. I will be sharing you the document relating to the important case laws. And under the topic of arrest and trial, you will find a number of cases, a number of important cases. Under the topic of arrest, there will be cases relating to the rights of the arrested persons. So these few judgments will be very important for the purpose of the examination. So go through your Bear Act, go through these sections, these chapters which have been mentioned here, and go through the case laws which I will be sharing afterwards. Then the next important topic is the trial, and here you have to go through these three chapters. Number one, the trial before court of sessions. So basically, sessions trial, trial of warrant cases, and the summary trial. And then you have to go through the chapter of plea bargaining, which was there in CRPC, but it was incorporated through an amendment under Chapter 21A. And afterwards in BNSS, it is a complete chapter in itself under Chapter 23, and it has been provided under Section 289 to 300. Then the other important topic is the maintenance of wives, children, and parents. So you can read the sections here, and then I will be providing you some important case laws also on this topic. And then the last topic under CRPC, which is very important for the purpose of this examination, is appeals, reference, and revision. You can go through Chapter 29 and 30 for CRPC, and Chapter 31 and 32 for BNSS. Regarding the BNSS, the details under BNSS, this primer document is sufficient, and you can go through it. Just go through the table which is provided under CRPC hand, and go through the salient features which is provided, right? Yeah, so from BNS's perspective, just go through these important points which have been mentioned here. And they have also mentioned some important case laws through which these particular provisions have been added upon. So it is also an add-on for you all. So be well versed with these highlights and the salient changes. See, for example, under the head of FIR, they have mentioned that zero FIR has also been provided under BNSS Section 173, Clause 1, which was not provided expressly under CRPC. It was done in practice due to certain guidelines of the judgment, but it was not expressly provided in CRPC. But it has been incorporated under BNSS, and it has been incorporated basically based on the observations which was laid down in Satvinder Kaur versus States case, right? So you can get these insights from this document, and I will suggest again and again to go through it once before attempting your examination. All the important case laws also have been incorporated in this document. The new timelines have been added in the new act, so these are also you can find here the timelines, the new timelines. Okay, so let's move forward to the next topic, that is our IEA. So under Indian Evidence Act, you have to be well versed with some substantial part of what you will not be finding under your Bear Act, and it will be hard to navigate and to find right there if you are not have if you are not well versed with the provisions, right? So the provisions regarding what is evidence, that is the definition of evidence, what is oral evidence, what is documentary evidence, primary and secondary evidence, the electronic records, everything. Just be very clear about it. Read it twice, thrice until you are clear. Since you cannot take the highlighted or underlined Bear Act, so you have to be very careful about it. That where it has been mentioned, what are the keywords in a certain definition. So although it is an open book examination, you can see the Bear Act, but you have to be well versed with the Bear Act. You have to be very confident about the provisions which have been provided under the act. It has to be on your fingertip. Say for example, if there is any question regarding documentary evidence, then you have to be very quick, and you it should be like okay, so this provision is under this section, and you just open that particular page and you attempt your question, because there is the limited time. So you can, although you can access your book, but at the same time you have to be well versed with the book, right? I have seen people who are going through who have who had large number of books. They had I think I appeared in AIB 17, and at that time this new rule was passed that we have to have this uh, barracks without comments. I went with the complete set, and other people were also there. Some who didn't knew about the new rule, they took a trolley bag full of books, but you have to attempt all those questions in just 3 hours. So you have to be very quick about it. So there was this person who was navigating through his Bear Act, and he was turning pages, and he was very he was panicking because he didn't even knew where he could find certain provision. So, say suppose there is some question regarding plea bargaining from CRPC, and you don't know the section where plea bargaining is mentioned. You don't even know the chapter in which plea bargaining is mentioned. So it will be very difficult for you to navigate, right? So just memorize all the sections of all the important topics which I have mentioned here, right? So regarding BSA, you sorry, Indian Evidence Act and BSA, be well versed with the topics of definition, in the Bare Act. What is evidence? What is oral and documentary evidence? What is primary and secondary evidence? Then you must be knowing the difference between substantive and procedural law. You have to be aware about the theoretical portion of the law also. Say, for example, the law of evidence is lex pori. So, what does it mean? It means that it is the law of the country or of the forum. It is governed by the law of nation, and it governs the proceedings, right? So it is not a substantive law. Some say that it is not completely a procedural law, but for the purpose of clarity, law of evidence comes under procedural law. So it governs the procedure, right? So CRPC tells you about how the procedure will be conducted, and Indian Evidence Act tells you about the procedures regarding the evidence, as well as what impact those evidences have. So it is a blend of procedural law, but it is not completely a procedural law also. So it is lex fori. Now, coming on to the topic of proved, disproved, and not proved. It is also the provision mentioned in the Bare Act itself, but since the language of Bare Act, of Indian Evidence Act, is very tough, so just go through it twice or thrice, or even you can go through it many times till it is very clear to you the difference between it, or whatever it is saying. Okay. Similar is the case with may presume, shall presume, and conclusive proof. And then there are kinds of presumptions, which is presumption of fact and presumption of law. And presumption of fact is covered under the Indian Evidence Act under the topic of may presume, under the definition of may presume. And the presumption of law has been covered under the topic of shall presume. Then we have the definitions of fact, fact and issue, and relevancy of fact, which is dealt under section 6 to 65 of Indian Evidence Act. Then you must be knowing what is a fact for the purpose of Indian Evidence Act, what is fact in issue, what is the relevant fact. Okay. Then the other topic which is important is the opinion of expert, which is provided under section 45 of the Evidence Act. And then you have to be well versed with the topic of confession and admission. Then what is oral evidence, and some principles relating to it. For example, the principle of res gestae. Okay, I have not mentioned it here. So, regarding oral evidence, you have to be well versed with this principle of res gestae, or what we say in the common language, hearsay evidence. So, go through it once. Then we have electronic and digital records as evidence, which is added upon by BSA. It has provided some very important update to the law of evidence, which is at par with the changes which has been there in the society, especially in the post-COVID era. And then the last important topic is the examination of witness, where you will be dealing with examination in chief, cross examination, leading questions, etc. So let me deal with some which I was saying, the definitions and differences between some important topics. So let's deal with what are the facts, what is fact in issue, and what is relevant fact, right? So law of evidence deals with the evidence of facts, and it is very important that these evidences has to be confined to the facts only. You cannot present any evidence in the court of law. So if a matter is being heard, then whatever evidence will be taken upon by the court, or it will be if it is going to be admitted by the court, then it has to be related to the facts only. Okay. Now, according to Section 3 of our Indian Evidence Act, fact means and include anything, state of thing, relation of things capable of being perceived by the senses. And number two is any mental condition of which any person is conscious. Okay. Now, what is fact and issue? So, Section 3 also defines what is fact and issue. And it says that the fact and issue means any fact from which, either by itself or in connection to any other fact, the very important expressions which I am going to recite now: the existence, non existence, nature, extent of any right, liability or disability, liability or disability asserted or denied by the parties in the suit or proceeding necessary follows, right? So basically fact and issue means any fact which is not sorry any fact which tells about the case. And what does it tell? It tells the existence or non-existence of something, some fact. It talks about the nature or extent of any right. It talks about the liability or the disability, and it asserts or denies any claim which is raised by the parties during the proceedings. Okay. Say, for example, if A is being tried for murder and B is the person who is deceased. So, in this case, what will be the fact and issue? So, there could be number of facts and issue. Number one will be if A is being tried and B is dead. So, number one question will be what? That if A has committed the murder of B. Also, number two, if say, suppose if he has committed the murder, whether he had intention to kill B, because intention is also a very important fact. It is a relevant fact when a murder case is being carried upon. And then third, there may be third fact in issue also, which is if whether the act which is being covered under the case is under any, does it fall under any general exception in the IPC or not? Okay, so these are some facts in issue on which the court will be dealing, and the proceeding will be carried out by the parties, by the council of the parties. Okay. Now, coming on to the topic of relevant facts. So we talked about what are facts under under Indian Evidence Act. Then we talk about what are the fact and issue. Now, what could be relevant facts? So Section 3 also defines relevant fact, and it says that one fact is said to be relevant to another when one is connected with the other in any of the ways referred to in the provision of the Act. Okay, so say there is certain fact, but it is not a fact and issue, but it is somehow related to fact and issue, then it will be called as relevant fact. Okay, so say suppose the fact and issue, the fact number 3 in issue of the case we discussed is whether A's act is covered under any exception mentioned under the chapter of general exceptions under IPC. So the fact that A was, say, suppose the act was committed, the murder of B was committed in Mumbai. So the fact that A was in Bangalore at the time of murder would be a relevant fact. Why? Because due to that fact that A was in Bangalore at the time of murder, it will be established that A's act falls under any general exception. Okay. So this is the difference between fact, fact in issue, and the relevant facts. Now let us discuss may presume, shall presume, and conclusive. Sorry for disturbance. So we were dealing with the topic of may presume, shall presume, and conclusive proof. So okay. From the bare provisions of the act, may presume is a presumption of a fact, right? And it is not defined in Indian Evidence Act. Sorry, the term presumption is not defined under Indian Evidence Act. However, there was this case of MS Narayana versus State of Kerala in the year 2006, where Supreme Court decided that presumption is any inference which is drawn from a proved fact. So if there is any presumption, if there is any inference which is drawn from a fact which is already proved, then it will be called as presumption. And in other words, it is a rule of law which allows the court to make inference by process of probable reasoning. So based on rational reasoning, the court will draw out any inference, and that will be called as presumption. Okay. So say suppose the case we were discussing, that A is being charged for the act of murder of B. So court may presume that A murdered B because at the time of the offense, two people saw A with a gun. There was the body of B lying nearby, and it was oozing blood. At the same time, there was some person who called uh, who called B, and his phone was ringing, but B was not picking up the phone, and A picked up that phone and he answered the phone, right? So, due to these circumstances, the court may presume that yes, A has committed the murder of B. But now this presumption will either be proved or it will be disproved, right, by the counsels of both the parties. And based on the results, he will be either acquitted or he will be held guilty. Now, what is conclusive proof? So conclusive proof is a kind of proof, right? Kind of fact which is proved in itself. So after that proof is being presented, there is no requirement of it being proved or disproved. If there is certain fact which due to after which there is no requirement to prove it or to disprove it, then it is a conclusive proof. And conclusive proof raises irrebuttable presumption of law. Okay, so it is being provided under which section? Anyone? Am I audible to you all? Okay, so can anyone guess where in the Evidence Act conclusive proof has been provided? See, this is the thing which you have to work upon. Before your examination, you have to be very clear about the concepts, and also you have to be clear as to where these provisions have been mentioned, where we can found those provisions. So you will found topics relating to proof, may presume, shall presume, conclusive proof under section 4 of Indian Evidence Act. So section 4 declares any fact to be conclusive proof when the court on proof of such fact regarding other fact, and it will not allow the other party to prove or to disprove the fact. It will completely rely upon that fact. Therefore, that presumption is irrebuttable. You cannot rebut that presumption, whatever it is, whatever fact it is. Say, for example, we have this very important section 112 of Indian Evidence Act. So it talks about the paternity of child. It says that if a child is being born within 280 days, which is the normal gestation period of a human female. So if a child is born out of a wedlock within 280 days of the dissolution of marriage, right? Then, according to section 112, It is conclusive proof that child is the legitimate child of the husband. Okay. Now, this fact is not rebuttable. No one can rebut this fact if the child is legitimate or not. You can prove, the parties can prove that marriage was dissolved and wife was living with someone else and whatever it is. But child will be legitimate son of the particular man. It is a conclusive proof. Okay. So it is one of the example, and you can find other examples also. But this is the standard of proof. This is the standard of presumption of law, which is irrebuttable, and therefore it is a conclusive proof, after which there is no need to prove or disprove that particular fact. Now, let us come upon to the topic of the recent addition of documentary and electronic records in the Indian Evidence Act. Sorry, in the Bharatiya Sakshya Adhiniyam. So, under the Bharatiya Sakshya Adhiniyam, now the word evidence will also, it shall include any information which is given electronically. So, under the Indian Evidence Act, it was not there. Whatever information was being given electronically was even, it was not even dealt under Indian Evidence Act, because it all boomed after the in the COVID era, in the pandemic era. So there is video conferencing. The court also allowed any documents sent by WhatsApp also as an evidence. So all these things have been incorporated under the BSA, and therefore now the word evidence, which is defined under BSA, will also include any information given electronically. So let me open the PDF bare act of the BSA. So we will deal with some certain provisions also. See, here you could see under section 2 clause E, evidence has been defined under BSA, and it means and include all the statements, including statements given electronically, which the court permits or requires to be made before it by witnesses in relation to matters of fact under inquiry, and such statements are called oral evidence. So basically, it also includes the change which is there is, it includes statements given electronically, right? And it will also be included under what we call as oral evidence. Okay. Then the evidence will also include all the documents, including electronic or digital records, which is produced for the inspection of court. And these documents will be called as documentary evidence, right? So before that, documentary evidences did not include electronic or digital records. Or even though, even after some judgments of the court, it was included, then it needed to have some certificates, or it has to be certified by someone. But now it is very well included in it. Now we already have discussed the definition of fact. Then we have discussed fact and issue, may presume, proved, not proved, proved relevant shall presume. जी okay, so now let's jump back to our document there. It's not okay. So one very important change which has been brought by the BSA is the scope of secondary evidence has been expanded. Okay. So previously, secondary evidence previously under Indian Evidence Act did not include the copies which was made from mechanical process, etc. Or even though if it was included afterwards due after certain amendments which was brought up afterwards, then it was not include it needed certain certification as to the truth of it and everything. But now the scope of secondary evidence has been expanded to include copies made from original through mechanical processes, copies made from or compared with the original. It also include counterpart of the documents against the parties who did not execute them, and it also include oral account of the contents of the document given by some person after uh, what? Sorry. Given by some person who has himself seen it and giving matching hash value of original record. It will be also admissible as proof of secondary evidence. So this is something which is at par with the changing needs of the society, and with the change in the technology which is being taken place in the society. Now coming on to this important topic, uh, all the three acts, they have deleted certain words and expressions from what was existing in the previous acts. So say for example, expressions like Parliament of the United Kingdom, or the Provincial Act, or the Crown Representative, or say Lahore, or Her Majesty, or by Privy Council, or the Court of Justice of England, barrister, all these words have been deleted. Why? Because now, in the present scenario, we are not using these words. These words are not in practice, and they were there because of the colonial rule, because Indian Evidence Act is of 1872. So these words were there, but now they have been completely done away. Also, words like vakil or pleader, barrister, attorney, they all have been replaced by the word advocate. So now we don't have any confusion between what is who is barrister or who is attorney, or what is difference between all the four kind of persons. Now everyone is advocate. The expressions like vakil, pleader, barrister, attorney, all of it means advocate in our current language. Now, the definition of document, which is provided under BSA section 21D, it is expanded to include electronic and digital records, right? Now, it is very important topic regarding relevancy of fact. Under section 4 of BSA, the principle of res geste is made applicable to both fact and issue and relevant fact. Before that, under section 6 of Indian Evidence Act, it was principle of res geste was only applicable to fact and issue. It was not applicable to any relevant fact. But now BSA has expanded its scope, and it has also made applicable to the relevant fact also. Okay. So this is how you will be navigating through this document. Be very well versed, read it carefully twice or thrice. Okay, so let's move on to the last topic, which we have to discuss, the examination of witness. Oh, sorry, just a minute. Okay, so let's discuss the topic of examination of witness under the BSA, or provision is almost the same under BSA and Indian Evidence Act. So we will be dealing with the BSA itself. So in the chapter 10 of BSA, we find this topic of examination of witnesses. Now, under this topic, we have to be well versed with the topic of examination in chief, the cross examination, and the topic of leading questions, then hostile witnesses, and accomplice, etc. So let us go through it one by one. Okay, so now in the topic of witnesses, we will also be having some very important case laws, which is important for the purpose of your examination. I will be sending you the document of case laws also. In the topic of witness, you have to be ready with the provisions of the act, and at the same time go through all the illustrations also, because some there are questions which are based on illustrations also. So for all the three acts, or say all the six acts, go through the illustrations also, right? Because the bare acts without comment will also have the illustrations, and you have to be well versed with the illustrations also. Sometimes they ask you questions based on illustration, and you will if you have not gone through the illustrations, you will think that it is some application based question, and you will be applying your mind. But at the same time, if you could find the answer carefully, it is well and good. But if you can not, then you can always remember these illustrations, and you will be able to solve the question. Okay, so now moving forward to the other topics. Second, what is left? Kind of presumption, fact and issue. But okay. Okay, let's talk about privileged communication. I have not mentioned it here, but it is also an important topic of Indian Evidence Act, so it may also come questions from it. So just read the sections from section 121 to 129 of the Indian Evidence Act, and the related sections in the Indian BSM. So under the topic of privileged communication, you have to be dealing with the communication between say spouses, the privileges given to the communication between judges and magistrate, or the official communication, right? So let's discuss privilege of judges and magistrate under section 121 of the Indian Evidence Act. So under Indian Evidence Act, section 121, it is provided that a judge or magistrate cannot be compelled except the special order of the higher court to give evidence about his own conduct relating to any case which he has tried, or anything which he came to know as a court in the course of trial. So personally, whatever they are doing, it is questionable. But when the court is in while under in the process of the trial, the court is in duty. So no judge or magistrate during their course of duty, whatever they have done, whatever information they have received, or whatever communication they have been into during the course of their duty uh, will not be compelled to present upon or to disclose. Okay, so this is the privilege which is provided to judges and magistrate to maintain the confidentiality and to also maintain impartiality. So it is under section 121. Now section 122 talks about the communications during marriage. So it says that the husband or wife are competent witnesses for and against each other, but at the same time, a wife or a husband cannot be compelled to disclose the communication of husband and wife, or husband to wife or wife to husband, if such communication is made during the continuance of marriage. So say there is a issue, a dispute relating to dissolution of marriage or to cruelty or anything which is emanating from marriage. But if there is any communication which is made during the continuance of marriage, then they will not be compelled by the law or the machinery to disclose such statement. However, they can do it on their own choice. Now, there is also some exceptions to this privilege. So, Section 122 says that these privilege cannot be claimed in four cases. Number one, when there is a civil suit or criminal proceeding between husband and wife. Now, if there is issue between husband and wife themselves, then you cannot say that there is this privilege and therefore I will not disclose this statement. Okay. Number two, the acts apart from the communication. So this privilege under section 122 is only allowed for the communication. It is not for the acts which is relating to the communication. So parties can testify, or they will be made to testify the conduct of each other, but not what they have said. So say for example, uh, uh, the husband of a woman, he came back at midnight on a certain day, and at that time there was blood stains on his shirt, right? So he came back, he came in the house, and the wife opened the door. He saw the blood stains over his clothes, and he was in so much hurry, and he was panicking, and he went straight back to sleep. Okay. Now, whatever communications which would have been taken place between husband and wife relating to what husband did and what wife asked him, that whatever he did, what happened and everything, she will not be made compelled to answer those questions or to testify that, but she will be compelled to testify the conduct of her husband. So court may ask whether at that particular time or that particular day her husband came late at night, whether he was wearing a shirt which was of certain color, and wife can testify that yes, it was. Also, they could ask whether it had some stains or anything like that. So she has to testify that yes, there were some blood stains, right? So the uh, uh, conduct is not privileged. Only the communication has been allowed to be privileged under section 122. Okay. Now, the next topic under privileged communication is under section 123, which talks about the evidence as to affairs of the state. So 123 prohibits any person to give evidence which is derived from any unpublished official document, right? Relating to the document relating to affairs of the state. However, there is one exception, except with the permission of the head of the department concerned. So if you are any person and you are working in certain department, in a certain government department, you are dealing with government affairs, but at the same time, you are not the person who is eligible to disclose any unpublished official document, right? You can only do it after your head of department gives you permission. Now, next is information as to commission of an offense. So, Section 125 provides that when a police officer or a magistrate starts a case, he cannot be compelled to say that who gave him the information on which he is initiating a certain case. Okay, so say we have these provisions under CRPC where a magistrate can sue a motor take action, or a police officer can make suo moto search, right? He can obtain the search warrant and he can proceed to search. Now they cannot be made to disclose who gave this information, because in practice, if it was allowed, then no one would be giving those information to these people, to these officials, right? So to protect the identity of the giver of the information, it is it is provided under section 125 that they will not be compelled to do so. Now section 126 to 129 deal with professional communications, and it says that any man of the legal profession who is an advocate is forbidden from disclosing whatever thing he has discussed with his client, his or her client, without client's consent, right? So these are some important topics from the three acts. I will share you the important case laws also. And once again, I'm telling you to read all the provisions which have been mentioned in this document at least. You can go through all the other also, but for the bare minimum, go through all these provisions once or twice or thrice till the time you are it is on your fingertip, so that you can at once you can just open your bare act and go through the provision at once when you see the question. Okay, so this is all from my side today. Just read the document. I am not extending the class so that you could have time to read all the documents which I have sent. Read this primer on the new case laws very well. Go through the bare act of the new criminal laws also, because you must have not studied it during your course also, so it is very new to you. So just read the provisions and especially the content of these three laws. Also, I would suggest to go through the tables carefully which is mentioned in this primer document. Okay, now if you have any questions you may ask, or we will end the session. No one has any question or any query, any confusion regarding the three subjects or anything? Okay, so Khushbu, I think there is no question from participants today, so you can end the session.
Sure, ma'am. Thank you so much for such a knowledgeable session. Also, I would like to thank everyone for joining. Have a great day. Thank you.
Thank you.